Welcome back to One Stop Law. Now, in a very significant judgment on 29th September 2022, the Supreme Court of India has upheld women's right to choice. The court has declared that all women are entitled to safe and legal abortion process, and making any distinction between married and unmarried women in this regard will be unconstitutional, as every woman, irrespective of their marital status, have right to choice over her body. Now, in this judgment, the court has taken into account the abortion rights of unmarried women on one side and the rights of women who are victims of marital rape on the other. So, in order to make the video not too long, I will discuss both these aspects into separate videos. Let's get started with the video. Now, recently in this September 2022, a three-judge bench of the Supreme Court has ruled that exclusion of unmarried women who conceive out of live-in relationship from the medical termination of pregnancy rules is unconstitutional. The decision follows an interim order of the Supreme Court given in July 2022, by which the court had allowed a 25-year-old unmarried woman to terminate her 23 weeks pregnancy. Now, before moving into the analysis of this September 2022 landmark judgment, let us first have a quick look into the background of this judgment, which came from a case named X versus Principal Secretary, Health and Family Welfare Department, Government of National Capital Delhi. Now, this judgment came from a case which arose when a 25-year-old unmarried woman, originally hailing from Manipur but now staying in Delhi, had approached the Delhi High Court seeking permission for termination of her pregnancy of 23 weeks and 5 days, stating that her pregnancy arose out of a consensual relationship. However, she could not give birth to the child as she was unmarried and her partner had refused to marry her. However, a division bench of the Delhi High Court comprising of the Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad refused to give that interim relief to her. The High Court observed that unmarried women whose pregnancy arose out of a consensual relationship was neither covered by any of the provisions of the Medical Termination of Pregnancy Act 1971 nor under its rules of 2003. She then filed an appeal in the Supreme Court of India, which overturned the Delhi High Court decision and passed an interim order on 21st of July 2022, allowing her to abort her pregnancy subject to a medical board constituted by the AIIMS of Delhi, concluding that the fetus could be aborted without risk to the life of the woman. Now, while giving the said interim order, the Supreme Court bench comprising of Justices D.Y. Chandrachud, Justice Suryakant and Justice A.S. Bopanna were of the view that the Delhi High Court had taken an unduly restrictive view in as much as Rule 3B of the maternity MTP rules speaks of change in marital status of women, followed by expressions widowhood or divorce. It held that expression change in marital status must be given a purposive interpretation. The bench took into account the amendments made to the MTP Act in 2021, which substituted the word husband in explanation 1 under section 3 clause 2 of the act with the word partner. The court thus observed that the amendment clearly shows that the parliament did not want to restrict abortion rights only to marital relationship, and that excluding unmarried women and single women from the ambit of the statute goes against the purpose of the legislation. The interim order stated, and I quote, "There is no basis to deny unmarried women the right to medically terminate the pregnancy when the same choice is available to other categories of women." On the above premises, the court had concluded that the petitioner's case prima facie falls within the ambit of the MTP Act. The court had also said that on August 23rd of 2022 that it will interpret the MTP Act and its rules to eliminate this superficial discrimination between married and unmarried women for allowing abortion till 24 weeks of pregnancy. It is in the light of this case and the continuation of the above stated interim order that the landmark abortion judgment came from the Supreme Court of India on 29 September 2022, wherein, noting that the 2021 amendment to the MTP Act does not make a distinction between married and unmarried women, the court held that unmarried women are also entitled to seek safe and legal abortion of pregnancy in the term of 20 to 24 weeks arising out of consensual relationship. A three-judge bench of the Supreme Court comprising of Justices D.Y. Chandrachud, A.S. Bopanna and J.B. Pardiwala said prohibiting single women with pregnancies up to 24 weeks from accessing abortion while allowing married women with the same term to get the care amounted to an artificial discrimination, and this artificial distinction is not constitutionally sustainable as being violative of the right to equality before law and equal protection as provided under Article 14 of the Constitution. The court stressed that marital status of women cannot be a ground to deprive her that right to free and safe abortion. The court says that to believe that only married couples have sexual intercourse is not practical, which is why unmarried women seeking abortion should be treated in equal right. And I quote the court here that the rights of reproductive autonomy, dignity, and privacy under Article 21 of the Constitution gives an unmarried woman the right of choice as to whether or not to bear a child on a similar footing as that of a married woman. If Rule 3b C Clause C is understood as only for married women, it would perpetuate the stereotype that only married women indulge in sexual activities. That is not constitutionally sustainable. The artificial distinction between married and unmarried women cannot be sustained. Women must have autonomy to have free exercise of these rights. Justice Chandrachud held. The source of a woman's pregnancy may also be the same vulnerability that applies to other women. There is a need to have a forward looking interpretation of the law, the court said. And I quote the court here again that the law should not decide the beneficiaries of a statute based on narrow patriarchal principles about what constitutes permissible sex. This would create invidious classification, Justice Chandrachud said in the judgment, which happens to coincide with the International Safe Abortion Day. The bench also showed its concern about the cones of unsafe abortion. The court said that the Medical Termination of Pregnancy Amendment Act of 2021 has addressed the continuing crisis of unsafe abortions in India because all close to 8 women die every day in India due to unsafe abortions. 67% of the abortions carried out in the country between 2007 and 2011 were classified as unsafe by the studies. One of the reasons the parliament was aware was that the women outside marriages and in poor families were left with no choice but to use unsafe or illegal ways to abort unwanted pregnancies. Hence, to address this issue, the 2021 amendment had included the word partner, showing that the law was not just concerned about women who undergo pregnancy within marriage, but also outside marriage too. After all, medical risk was the same for both married and unmarried women. The court said that the artificial distinction between married and unmarried women was not constitutionally sustainable. Justice Chandrachud observed in his verdict, and I quote him, the benefits of law extend equally to single and married women. If law with unwanted pregnancies are forced to carry them out to full term, the state would be stripping off their right to determine the immediate and long term paths their lives would take and deprive women of autonomy not only over their bodies but also over their lives. This will be an affront to their dignity. The court held that reproductive autonomy required every pregnant woman to have their intrinsic right to choose to have or not have to undergo abortion without any consent or authorization from a third party. I quote the court here. It said, the fetus lies on the woman's body to sustain. Therefore, the decision to terminate it is firmly rooted in their right of bodily autonomy. It is pertinent to note here that the judgment also expanded the ambit of the term reproductive rights. It was not restricted to have or have not children, but reproductive rights of women included a constellation of rights, entitlements, and freedoms for women. As I quote Justice Chandrachud here, he said, reproductive rights include the right to access education and information about contraception and sexual health, the right to decide whether or what type of contraceptives to use, the right to choose whether or when to have children, the right to choose the number of children, the right to choose safe and legal abortion, the right to reproductive health care. Women must also have the autonomy to make decisions on these rights, free from coercion or violence. Thus, we see that the bench led by Justice D.Y. Chandrachud pried open the restrictive grip of a 51-year-old Indian abortion law, which barred unmarried women from terminating pregnancies up to 24 weeks old with the help of medical practitioners. Moreover, this landmark ruling, which emphasizes female autonomy in accessing safe and legal abortion, has been coincidentally delivered on the International Safe Abortion Day itself, which is on 29th September. So that's all for this video. In this video, I have restricted myself to the discussion on the part of right to abortion of unmarried women. In my upcoming video, first I will discuss the right to abortion of victims of marital rape, and then we will have a concluding third video where I will discuss the impact or the far-reaching effect of this landmark decision. Till I see you in some other video. Thank you all.